Welcome back. Well, let's talk about the news with regards to the hospitals. Association of Doctors and Hospitals have moved the Supreme Court against possibility of fixed rates. Ashmit joins in with details on this. Ashmit, go ahead.
Well, this is an important matter where a PIL had been filed, which essentially had claimed provisions under the law that sought for a certain band of rates to be prescribed for various hospitals. Now, what is important is that today we saw a whole host of petitions being filed by various associations of doctors as well as hospitals who have challenged this PIL, and not just challenged, have challenged the provision under law that provides for this part. This provision that we're speaking of is essentially Rule 9 of the Clinical Establishment Rules of 2012. Rule 9 of Clinical Establishment Rules essentially provides the centre the power to prescribe a range of rates for hospitals. Now, this was fairly contested by doctors as well as hospitals. In fact, they argue that if such a policy is implemented, then investors, especially in the healthcare space, bringing big tech to Indian healthcare picture will not happen. Investors will be wary if such fixation of rates is allowed, saying that we cannot have a one-size-fits-all approach as far as the healthcare space is concerned, that the Rule 9 has been challenged, that there is no valid power that the centre can exercise for going ahead and for fixing such rates. In fact, even going on to say that while the medical profession invites more regulation, there is no space available for such fixation of rates. Prima facie, the Apex Court made some interesting observations. Number one, the Supreme Court observed that questioned this power that is available with the centre for prescribing uniform rates. Went on to say that rates are a function of market forces, that one doctor may charge 100 rupees, the other may charge 10,000, saying that any fixation of rates could possibly lead to underhanded practices, and also, in fact, question the lawyers if the lawyers on their part would welcome such fixation of rates. So strong line of inquiry here by the doctors, prima facie observations here by the Apex Court. The Supreme Court for now has resisted from taking any measure one way or the other, has asked for the central government to come back to this petition of the doctors, has sought a response from the centre, will next hear this case on September 10th.
Right, interesting comments coming in from the Supreme Court out there, and important ones as well. You know, what stood out, Ekta, for me was that the Supreme Court saying that if there is a fixated price, then hospitals may perhaps resort to some underhand activities, etc. as well. So maybe valid points there.
Yes, absolutely. You know, there could be lots of permutations and combinations if in case there is fixed rate. We ourselves could not develop in terms of technology because, you know, a robotic surgery itself costs so much now. If those kind of rates are fixed, you won't even be able to, you know, probably afford a robot when it comes to surgery. And that also has impacts on, say, medical tourism into the country, which is also picking up. So there are
that the Supreme Court would be walking, right? On the one hand, you have all these advanced technologies and the prices that they would be charging for this. And on the other, you'll have a large population which cannot afford basic
absolutely. That is the dichotomy of the Indian healthcare system, which I think we've been battling for ever. But that is, you know, the point of fixed rates is exactly that. But